Hello and welcome to the Minimum Competence episode for Thursday, October 3rd, 2024. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, we discuss 8 states voting on banning non-citizen voters, major Supreme Court cases impacting employment law, the SEC's appeal in the Ripple case, and Trump's January 6th legal battles. Let's remember, the key to success is to focus on goals, not obstacles, and read today's legal news. On this day in legal history, October 3rd, 1965, President Lyndon B. Johnson signed the Immigration and Nationality Act into law, marking a significant shift in U.S. immigration policy. This legislation, also known as the Hart-Celler Act, abolished the national origins quota system that had been in place since 1924, which favored European immigrants and limited others. Johnson, during a ceremony at the Statue of Liberty, called the old system un-American and discriminatory. The new law established a more equitable process, allowing a set number of immigrants from each country with no preference based on nationality. The act also prioritized family reunification and skilled labor, changing the face of American immigration by allowing greater numbers of immigrants from Asia, Africa, and Latin America. Though the total cap on immigration was still in place, the changes sparked a demographic transformation that led to the multicultural U.S. society seen today. This law was part of Johnson's broader Great Society program aimed at promoting civil rights and social reforms. Despite fears at the time that it would open the floodgates for immigration, the act is now regarded as a key milestone in modernizing U.S. immigration policy. On November 5th, 2024, 8 U.S. states will vote on constitutional amendments to ban non-citizens from voting, even though it is already illegal. These states include key swing states, North Carolina and Wisconsin, as well as Republican strongholds like Idaho, Iowa, and South Carolina. Supporters of the measures argue they address concerns over illegal immigration and the integrity of U.S. elections. Critics, however, view this as part of a broader effort by Donald Trump and his allies to undermine confidence in the electoral process. They fear it could be used to challenge the results if Trump loses the presidential election. While some localities allow legal non-citizens to vote in municipal elections, non-citizen voting in federal elections remains illegal. Independent studies and election officials from both parties confirm that non-citizen voting is extremely rare. Nevertheless, and notwithstanding facts, evidence, and all good sense, Trump's repeated claims of widespread illegal voting, especially from immigrants, have fueled distrust among his supporters despite that lack of evidence. These ballot measures follow ongoing lawsuits and legislative attempts by Republicans to tighten voter registration rules. The U.S. Supreme Court will address several key employment issues in its upcoming term. One significant case, Williams v. Washington, questions whether workers must exhaust state administrative remedies before filing federal civil rights claims in state court. Another case, Lackey v. Stinney, will explore whether securing a preliminary injunction in civil rights litigation qualifies a plaintiff as a prevailing party entitled to attorney's fees. In Medical Marijuana Inc. v. Horn, the justices will consider if a truck driver can use the RICO Act to sue a CBD manufacturer whose mislabeled product allegedly caused him to fail a drug test and lose his job. This case hinges on whether job loss qualifies as an economic injury under RICO. Additionally, the court will evaluate the burden employers must meet when proving workers are exempt from federal overtime requirements in EMD Sales Inc. v. Carrera U.S. The case could affect how easily employees can claim overtime pay under the Fair Labor Standards Act. Lastly, Stanley v. City of Sanford will clarify whether the Americans with Disabilities Act, or ADA, protects former employees against discrimination in post-employment policies. This decision could impact how employers handle benefits for disabled ex-workers. The U.S. Securities and Exchange Commission, or SEC, has appealed a court ruling that ordered Ripple Labs, Inc. to pay a $125 million civil penalty for improperly selling its XRP token, far less than the $2 billion the SEC initially sought. The lawsuit, filed in 2020, accused Ripple of illegally raising funds by selling XRP without registering it as a security. The case is a significant one for the cryptocurrency industry, as it could shape the SEC's authority over digital assets. In a 2023 ruling, U.S. District Judge Annalisa Torres determined that XRP sales to institutional investors were subject to securities laws, but those to retail investors were not, a decision seen as a win for Ripple and the broader crypto sector. While the SEC sought nearly $2 billion in penalties and disgorgements, Torres only imposed the smaller civil penalty. Ripple's CEO, Brad Garlinghouse, criticized the SEC's persistence in the case, claiming it harmed the agency's reputation and did not protect investors. The SEC, however, maintains that the decision contradicts long-standing Supreme Court precedent and securities law, prompting its appeal. Prosecutors have argued that Donald Trump should stand trial for his efforts to overturn the 2020 election, emphasizing that his actions were those of a private citizen not protected by presidential immunity. A newly unsealed court brief details Trump's pressure on former Vice President Mike Pence to intervene in the certification of Joe Biden's victory. The filing also recounts how Trump dismissed concerns for Pence's safety during the Capitol riot with a remark of, "So what," when informed that Pence was in danger. The filing reveals prosecutors' intention to use swing state officials, iPhone data, and private conversations to demonstrate Trump's knowledge that his fraud claims were false. They contend Trump continued to pursue election interference despite being informed by close advisors, including Pence, that his claims were baseless. Additionally, the government will argue that Trump, as a candidate, pressed state officials to reject Biden's win despite having no official role in the electoral process. Trump's defense is focused on his communications with Pence, suggesting these might be protected by presidential immunity. However, the prosecution asserts that Trump's conduct, including his pressure on Pence, was part of a private scheme not covered by immunity guidelines. And with that, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers, and for sticking with me while I don't sound so good. If you're looking for more than Minimum Competence, links to further reading and all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in the story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, small deeds done are better than great deeds planned.